argument. Mr. Domina.
May it please the Court, we are here today with a facial challenge to a bill passed by the Nebraska legislature in 2012 in some haste. The legislature, when it enacted this bill, violated 4 specific components of the Nebraska Constitution. And we want to talk to you about what those violations are. We have, of course, addressed those in our briefs, but may I give it voice here today. First of all, the legislature gave the governor of Nebraska authority over 2 subjects that it cannot properly delegate because the subjects involve the lawmaking function. And in order to understand the core of our argument, I think it's important to pay attention to the structure of the Nebraska State Constitution. Article 1 of our Constitution is our Bill of Rights. It's not the Federal Bill of Rights, it's different. It's the Nebraska Bill of Rights. Article 2 of our Constitution is devoted to a single section which says we shall be governed by a government which shall consist of 3 departments: a legislative department, an executive department, and a judicial department. The 3rd article governs the legislature, the 4th the executive, and the 5th the judiciary. In the 4th article of our Constitution, the governor is one of the offices and officers mentioned, but only one. The Nebraska Public Service Commission is a constitutional organization in the executive article of our Constitution. The Nebraska legislature has some authority over the Public Service Commission, and it has, when confronted with matters involving common carriers, a clear choice identified by the Constitution and by the decisions of the Nebraska Supreme Court. That choice is this: when a common carrier needs regulation in our state, the legislature can either regulate that area of commercial activity in which the common carrier is engaged in its entirety, to use the words of the court, occupy the field, or in the alternative, the legislature can commit the execution of the law that it gives to the Public Service Commission. But the legislature cannot commit to the governor of Nebraska regulatory authority over a common carrier. Our citizens decided in 1885 to create a state railway commission, now called a Public Service Commission. And that decision was enshrined in the executive article of our Constitution. The Supreme Court reminds us once in a while that a constitution is the supreme law of the state. It is a law that transcends all others. It is not subject to the whim or caprice of the legislature. It must be respected. In LB 1161, the legislature created a route for a class of common carriers, major oil pipelines, to choose 2 pathways to seek authority to build and conduct pipeline activity in our state. One of those pathways is to the Public Service Commission. The other of those pathways is to the governor of Nebraska. And it's the choice of the applicant to choose the gubernatorial pathway or the Public Service Commission pathway. If the gubernatorial route is chosen under the statute, the governor can grant the authority to build the pipeline, or he can decline to do that, in which event the Public Service Commission is a default route that is before the applicant, even though the applicant chose to take the gubernatorial pathway. Our position is very simple and very straightforward. The legislature has the power to make laws to regulate common carriers. It has the authority to occupy the field. It can pass a comprehensive code like a uniform commercial code and give to the people of the state all of the law that will govern that common carrier. But if it does not do that, it must give the rest of the authority over which it, the legislature, chooses not to exercise power strictly and solely to the Public Service Commission. Now, there's an important reason why that is a part of the public policy of our state. In 1885, there was much concern that railroads had too much power. In 1885, the United States passed its first antitrust law because it was focused on railroads and the power they had. And that movement led to the State Railway Commission in our state. Our people decided to make it a part of the supreme law of our state that we would not entrust these kinds of decisions of great magnitude to a single elected office holder. We would give it to a less partisan group, a group more representative of the entire state, a group then called the State Railway Commission, now called the Public Service Commission. The legislature simply violated that supreme law of the state when it adopted LB 1161. I might say this, the Public Service Commission is not the only constitutional body that is somewhat like the character that it has, though it is the only one in Article 4 of the Constitution. Article 7 of the state constitution involving education creates a Board of Regents, and it creates a Board of Educational Lands and Funds, two constitutional organizations over which the legislature is given authority, but out of which activity the office of governor is cut, excluded. The legislature cannot commit to the governor the power to govern the university. It cannot commit to the governor the power to set rates or terms for the rental of 1 million acres of school land owned by Nebraska and leased by Nebraskans, and it cannot give the governor that authority over the Public Service Commission. There is a second improper delegation before you in this statute which we challenge, and that delegation involves the power of eminent domain. When a common carrier is authorized to do business in our state, if the legislature chooses, the legislature can authorize that class of carrier to exercise the power of eminent domain to build infrastructure. Telephones, for example, telephone companies can exercise the power of eminent domain, but only because the legislature gave it to them. In LB 1161, because there are two pathways to qualifying to be a pipeline, the legislature has committed to the governor on one of those pathways the authority to decide what pipeline company and what pipeline will be built and what pipeline company can exercise the power of eminent domain. That's not a proper delegation. The legislature owns the power of eminent domain. It has plenary authority over it. The Supreme Court said so in the Burnett case, cited in the briefs of both parties. And, Your Honor, that plenary authority must be exercised by the legislature even to confer eminent domain on a county or a city or a school district. The legislature can't say, Governor, you decide which counties or any if counties can have eminent domain. The legislature must do it. In this case, the legislature passes to a for-profit corporation the power of eminent domain, but does so by giving all of the decision-making control over that to the office of governor, who can act alone. And this is a particularly egregious violation of this particular segment of the Nebraska Constitution for this reason. Here we have a competition for property rights that does not run between a private citizen and the public. This is a competition for property rights between a private citizen and a private corporation. This is citizens who are trying to make a living and a corporation that wants to make a living its way instead. The legislature is not empowered by our Constitution, by Article 2, Section 1, or by Article 10, Section 6, which specifically calls out its authority over eminent domain to delegate that power. There is a third problem with this statute. And this third problem is so fundamental that once before in our history, it cost the state, because of a legislative error, its entire property tax structure. And that error in LB 1161 is that there is no provision for judicial review. Your Honor, the decision-making process here belongs to the Public Service Commission. If it were held by the Public Service Commission, the decisions of the PSC are appealable to the Nebraska Court of Appeals under Section 75-143. There is no appellate review of the governor's decision, yet there would be appellate review of the Public Service Commission's decision under this same bill. So because the gubernatorial pathway is present, because it is an improper delegation of authority over common carriers and the power of eminent domain, and because it is not subject to judicial review, LB 1161 fails. And in this third area, there is a second violation of Article 2, Section 1 of our Constitution, that provision which departmentalizes government into three parts. LB 1161 attempts to give the legislative power to the governor. It then attempts to seal off the governor's decision from review by the courts. In its most fundamental sense, the legislature gives the law, the executive enforces the law, and the court referees whether each of them did what they were supposed to do in accordance with the law that governs how they do it. But this bill would allow the governor to make a decision that the legislature is supposed to make and permit no judicial oversight or review of that decision. In this case, that lack of judicial review, which is always egregious because it violates fundamental due process rights of applicants and objectors, it denies them a hearing. It denies them an opportunity to present evidence. It denies them an opportunity to have legal standards applied to the decision-making process that must accompany the execution of a law given by the legislature. But there are no standards given in this bill. The governor and the PSC are without guidance at what must be found to determine whether a major oil pipeline company should be permitted to build something. Standardless legislation, committing an offense by delegating the power that is required to be exercised by the legislature or conferred to the PSC, and in that process empowering the governor to give an organization or a body of them in a category the authority to exercise eminent domain. Each and all of those things are fundamental violations of the Constitution. There is one more. In this statute, LB 1161, the state of Nebraska is obligated to lend its credit to the process of financing an inquiry into the environmental fitness of an applicant for a pipeline. LB 1161 says such a study shall be undertaken, the state shall pay for it, and the applicant shall repay the state. So from the moment there is an application filed until the moment the state treasurer issues a check, the state's credit is committed to paying whatever bills are incurred to fulfill that legislative mandate. From the moment the treasurer decides to issue the check, which could be 60 days, could be 90 days, could be when, and could be after the applicant pays the state's credit is at risk. After the check is cut, the taxpayers' funds are out, and they represent credit extended to the private applicant. In its brief, the state says that that argument calls up an important distinction, the distinction between lending credit and lending money. They say that since this statute requires the state to pay the bills, it doesn't lend its credit, it just lends its money. And the Attorney General has suggested in its submissions that there is a constitutional difference in that regard. I would submit that no banker in this state would keep his bank open long observing that kind of logic. Once the state is committed to pay the bill, its credit is extended. Once it writes the check and spends the money, its credit is exhausted. It has lost the funds, and it has no assurance except that of an unsecured creditor that it might be repaid someday down the road. That is prohibited by Article 8, Section 3 of the Nebraska Constitution. There is, at least arguably, one more problem with the constitutional issue. I'm going to only mention it in passing, and that is that we think this bill is also special legislation. We understand and know from the legislative history that when this bill, LB 1161, was passed, and engrafted in it was a deadline for qualifying companies that was geared by the pendency of an application for an international border crossing permit with the President of the United States of America, that there was one company with such an application pending. We can't find any time in the history of our state when any other company has ever had such an application pending, and we can see nothing in the legislative history to suggest that any member of the unicameral expected another company had an interest. This bill was passed for a single non-resident of this state. And if it stands, it would empower the governor to empower that non-resident to take the land of our people from the South Dakota border to the Kansas border and use it for the company's profit and deprive the people who own the land of enjoying the fruits of that land on an annual basis. When the legislature did that, Your Honor, it provided nothing about how compensation would be paid. So presumably, if the proceeding is in eminent domain and an easement is taken, so annual profits can be earned, the Nebraska resident gets one payment, one harvest off the land, and forever no payments thereafter, although the private citizen who takes it reaps an annual reward. The legislature could have, at a minimum, done a better job with that, though that isn't a constitutional infirmity. It's an illustration of why this bill represents ill-conceived legislative thought and is a product of haste making waste. Thank you.
Thank you, Mr. Domina. Ms. Vaughn, argument on behalf of the defendants.
Thank you, Your Honor. Plaintiffs today have challenged the constitutionality of LB 1161, a 2012 bill that modified the Major Oil Pipeline Siting Act. But before we get to the merits of our claims, we reassert our jurisdictional objections. Now that we're at trial, the burden is upon the plaintiffs to show that they have suffered an injury in fact and have standing to bring their claims. Plaintiffs rely on a limited exception to the injury in fact requirements under standing to argue that as taxpayers for the state of Nebraska, that there has been an unlawful expenditure of state funds. However, under the plain language of LB 1161, there has been no expenditure of public funds. Section 8 of 1161 makes abundantly clear that the applicant must reimburse DEQ for all expenditures associated with the environmental review conducted under 1161. This includes NDEQ employee overtime, DEQ employee health insurance, the costs in hiring consultants, and any other costs which DEQ incurs in association with accomplishing this environmental review. And the evidence shows that in the one instance that LB 1161 has been applied since its adoption in 2012, that the pipeline company has in fact reimbursed all expenditures for their environmental review. Ultimately, the pipeline company is the one here that bears the burden of the costs. And under this facial challenge, we cannot rely on the risk of non-payment to argue that the taxpayers here have standing to challenge LB 1161. Before we reach the merits of the arguments here, we'd like to point out that plaintiffs have brought a facial challenge, and the burden is on them to when there's a presumption of constitutionality to show that LB 1161 is unconstitutional. We submit that plaintiffs have been will be unable to meet that burden. The first argument we'd like to address is plaintiffs' due process clause violations. Article 1, Section 3 of the Nebraska Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. DEQ and the governor, the DEQ did an environmental review and the governor ultimately would approve the route of a particular pipeline. But when that happens, when the route is approved, there has not been a deprivation of life, liberty, or property. All LB 1161 does, and the approval that is obtained either by the Public Service Commission or the DEQ, is approval of a right, and it grants a pipeline company the authority to utilize eminent domain along that particular route. Deprivation of property, which is entitled to due process, only happens when and if a pipeline company engages in condemnation proceedings under the eminent domain statutes. Nothing within LB 1161 in any way modifies the condemnation proceedings in the eminent domain statutes, which have been in place since the 1960s. And in fact, under Nebraska Revised Statute 76720, plaintiffs, when they're subject to this condemnation proceeding, can bring a challenge to determine whether or not this public improvement serves a public purpose that justifies the taking of their property. Furthermore, it provides that they shall be fairly compensated for the fair market value of the property that is taken in association of the condemnation proceedings. Turning now to plaintiffs' claims regarding unlawful delegation of the Public Service Commission's authority. Plaintiffs are attempting to rewrite history a bit in arguing that approval of the pipeline route falls under the constitutional authority afforded to the Public Service Commission under Article 4, Section 20. If the Public Service Commission had had authority to regulate routes of pipelines, then why did the governor have to call a special session in the fall of 2011 to create the Major Oil Pipeline Siting Act, which was designed to regulate routes of all future pipelines? The Public Service Commission's jurisdiction simply does not stretch as far as the plaintiffs would ask this court to believe. We're not conceding that 1161 applies to common carriers, but even if it does, the Constitution is clear that the legislature can limit the jurisdiction of the Public Service Commission with specific legislation, and that is precisely what has happened with LB 1161. Finally, we touch briefly on the unlawful pledge of state credit prohibition. Article 13, Section 3 prohibits a state from acting as a guarantor. Nothing within LB 1161 is an extension of state credit. It simply requires DEQ to conduct an evaluation, an environmental evaluation for the benefit of all Nebraskans to determine that the route upon which the pipeline is to be laid is an environmentally sound route to be utilized, and requires the pipeline company to reimburse any expenses associated with that review. That's not an extension of state credit. That's not the state acting as a guarantor. A guarantor is when I co-sign for my son's car loan. I'm acting as a guarantor and extending my credit, promising that if my son doesn't pay for his car loan, that I will do so. Nothing within 1161 requires the state to extend their credit. It's simply the ultimate obligation is on the pipeline company to reimburse the DEQ for any costs that are associated with their environmental review. Plaintiffs have set forth a number of other claims in their complaint, including special legislation and a violation of the separation of powers doctrines. We're not going to raise those here in the interest of judicial economy. They're set forth in our briefs, and we stand on the arguments that are in our briefs. And with that, we would submit the case to the court.
Thank you, Ms. Bunn. Mr. Domina, reply.
May it please the court, I'll address standing first. Counsel suggests that these three plaintiffs lack standing to bring this case because they don't have a special injury. Well, they're here as taxpayers, as ratepayers, as property owners whose property was affected and is affected by this project, and their affidavits establish that. This is, I believe, the 11th consecutive case involving a challenge to a Nebraska statute in which the Attorney General's office has argued that the plaintiff lacked standing. In the previous 10, the Attorney General's office has failed in that argument, and it should fail here too. We collected and cited those cases in our reply brief at paragraph 11. There is an argument made here that due process is not violated because, after all, the person whose property is affected and will be condemned can not only have a hearing and a trial before the price is determined for his land or hers to be taken, but in addition can invoke Section 76720 to at that time challenge the public necessity of the project. Well, now that is a circuitous argument because this bill is defended by the defense on the basis that it empowers the governor to make unilaterally, absolutely, firmly, unconditionally, finally, and without judicial review, the decision that this applicant can build this pipeline in this place and use eminent domain to build it. Section 76720 is rendered null and void by this statute. The Attorney General's office argues that there is no unlawful delegation of the authority over common carriers and that we are attempting to rewrite history with our position in this case. In 1989, the Nebraska legislature decided State ex-rel Robert Spire, who was then the Attorney General of Nebraska, versus Northwestern Bell in favor of the Attorney General's office when it took the opposite point of view it takes here today, because there was an unlawful delegation at that time away from the Public Service Commission. The history that is on our side is the history of the application of Article 4, Section 20 of the Nebraska Constitution to the cases that have come before the Nebraska Supreme Court. State ex-rel Spire versus Northwestern Bell being the most recent, and a series of precedent being cited in it and in our briefs. The Attorney General's office ignores history. We do not seek to rewrite it, we seek to extend it. Finally, there is an argument that Article 13, Section 3 is not offended here because there is no commitment of the state's credit. And the example offered is a parent's co-signature or guarantee of a child's automobile loan. The state does not have children. It has citizens. The state does not adopt companies. It considers their applications. The legislature said the state would pay the applicant's bills up to $2 million. That is exactly like telling a citizen that the citizen, by act of the legislature, doesn't have to worry about the citizen's child's bills because the legislature will cover them for 60 days. That's a pledge of the credit of the state. This statute ought not survive. Thank you.
Thank you. I appreciate the briefing of the parties. I appreciate the argument that I've heard this afternoon. I'm going to take all of the issues under advisement pending receipt and review of the additional briefing, and I will issue a written opinion. Thank you, folks.
Thank you.
May we be excused?
We're adjourned and you're excused. Thank you, everyone.